traditionally is, the members do not know the business of the House because the business of the House is decided by what is called the Business Advisory Committee. And only some members of the House of political parties are members of that committee. So every week, couple of times, every week, a meeting takes place as to what should be the business for the next week. So that's decided and then it is announced in the House. On that basis, the whip then informs the members of the House that this is going to be the business. These are the bills that are to be debated. This is the position that we have to take on the bills. Therefore, you please prepare your speeches in the context of the position of the party. That's the job of the whip. Now, it's not that. That is not the job of somebody who says, I am a group leader and I will decide. That is why the whip is appointed by the political party, for that very reason.
On general parliamentary business, how specific are the whips? I mean, this is not unrelated to this case. I mean,
a WhatsApp message is sent to us. Three lines at the end. Underlining, otherwise you have to be present, otherwise action will be taken against. This is a whip. And you come and vote, and this is how you have to vote. A 3-line whip will come. Vote for this bill. Vote against this resolution. So each one under a WhatsApp, that message is sent. So we have to be present. They're very generous, because while we argue our cases, proceedings are going on, so we're not present. So they don't trouble us too much. The fact of the matter is, if you want to practice, you should practice. You want to be in Parliament, devote your time to Parliament. It's what happens is that the key issues of the party are nowadays before the court. And they want us to be here. And slowly Mr. Jethmalani will realize as the burden increases that he might also have to do that.
Just one second aside about coming out of the halls of Parliament, a very leading left leader mentioned inside the House that lawyers, chartered accountants, doctors and other similar people should not be in Parliament. They should consider it on their profession. Mr. Jethmalani and I were talking in the lobbies once. So when he came out, a good friend of ours, we told him that you want Parliament only to consist of unemployed and unemployable persons.
Don't say that. Don't say that publicly.
This is what happened. He said it generally for a lot of us. He says, I'm taking his example. He said it for a large class of professions, not lawyers alone. Yeah. So there is a certain amount of input you bring in if you are otherwise also gainfully employed.
That's true. But lawyers in many jurisdictions are not allowed to do both things. So then it says, any difference of opinion must be first ventilate and fight within the party. Kindly see that. Your Lordship asked me that question, then what does he do? He has to ventilate it within the party, call a meeting. Then, more important, the membership of the House does not become his private property, nor can he trade in it. How prescient, these words are. That's not his private property, nor can he trade in it. I mean, I'm sure, he wasn't in Assam for cleansing his conscience, There were bigger issues that were to be dealt with in Assam, somewhat. It is a trust that he is in the members of a trustee. He cannot also say that he will take advantage of the name and facilities of a political party, fight the election on the ticket of that party and succeed, but he will not subject to the discipline of the political party. This is simply unthinkable, besides being unethical and immoral. He has to abide by the party discipline within the House. He might fight within the party to have his point of view or policies adopted by the party, but once the party takes a decision one way or the other and issues the whip, he shall have to abide by it or resign and go out. This, in essence, tells you, what the contours of the conduct of a member of the legislature in the House should be. And in what circumstances, and there are only two, that he can actually disobey the whip. One, he can take the permission of the leader, and two, he says something contrary to the whip and the party condones it. And this Law Commission report led to the 91st Constitutional Amendment, deleting paragraph 3. No, I cannot go to the speaker. No member of the legislature can go to the speaker in Parliament, Rajya Sabha or Lok Sabha, that I want to speak. He has no choice in the matter. The party will decide who is the party, Malad. It's the leader. That on this issue, on cooperative societies, my member in the legislature knows more about cooperative societies than somebody else. Therefore, allow him to lead the debate. In finance, Malad, who leads the debate in Rajya Sabha? Mr. Chidambaram. Who decides that? The party. So, Malad, each person has his expertise on education, on telecom. There'll be different people in the house who will be espousing the cause of that subject matter because he has expertise. And who decides that? Not even the leader. Leader will put up the name to the party president or the UPA chairperson or the party. And then they will say, okay, now you let him decide. Let him debate. So this whole argument and sitting in Assam, I can throw you out, I can throw the whip out, and I can change the leader of the house, and I'll proclaim myself to the leader of the house. What is the speaker going to do when you send it back to the speaker? And this realization dawned 2 years afterwards, Maharaj, when he was a minister and all that. The chief whip is the eyes and ears of the leader of the party, so far as the members are concerned. He conveys the wishes of the leader to the members of the party and keeps the leader informed of the current opinion in the party, as also the moods and inclinations of individual members when these deserve special notices. During sessions in his capacity as advisor to the leader, he normally meets the Prime Minister not only on one set interview daily, but also several times in the course of the day for brief consultations. Why, Malas? What happens is there is hangama in the house. People are going to go to the well. You immediately have a meeting with the leader. What should we do? Because the house is adjourned for 15 minutes, 20 minutes, half an hour. You go back to the leader, you have a quiet meeting, Malas. The whip will have a quiet meeting, a decision will be taken, conveyed to the legislature. So to say, Malas, that I am 40 members of the legislative party, I can do what I like, I am a separate group, I am a separate entity, I can remove you, it's unthinkable in parliamentary democracy. Unthinkable. And Malas, this per se, that's why I use the expression per se, is voluntarily given up membership of the party, per se. Apart from making the house and keeping essentials for transaction of business, the chief whip has the whip hand in shaping the course, tone and tenor of debate on special occasions, for he selects the speakers from his party and hands over a list to the speaker for facilitating the process of catching his eyes. The responsibility of keeping everybody at his post and keeping his party united, strong and well-knit falls on him. He selects members for the select committees and other parliamentary and government assignments, keeping in view the background, experience, aptitude, qualifications of members of his party. This gives him, supposing Malas, a select committee is to be formed and Malas, a person to be nominated. Who decides that? If 40 members of the House will say, no, because we are 40, we nominate this person? No. The whip will tell the speaker that this is our nominee on this select committee or this joint committee or the standing committee. So this gives him wide power of patronage, which comes handy in keeping with party members amenable to his influence. It is thus clear from a reading of the aforesaid that the whip forms an important link, an umbilical cord between the political party and the legislatures. The whip enforces the directions of the political party. Then, Malas, there is a discussion about how the term political party as well as actually was not there in the constitution earlier, or not constitution, even otherwise was not there in a statute. Then was 29A of the representation. I don't have to go through the history, Malas. We are short of time, and I don't want to, Malas, take time unnecessarily. My learned friend can, if he wishes, to deal with some of this. Now, Malas, your Lordship knows that under the Constitution, there are areas where the governor has discretionary powers, subject to 3 exceptions, which are given in Nabam Rebia. This is an area when, in the beginning, Malas, there's an election that takes place. Who is to form the government? There is enough discretion with the governor. He will see as to whether there's a pre-poll alliance, and if the pre-poll alliance has majority, he'll call the leader in the normally. I mean, there are exceptions. There's a if he doesn't get a pre-poll alliance majority, he'll call a post-poll alliance. And If not, he'll otherwise see if a majority can be cobbled up by a leader who has the confidence of the House, who may have the confidence of the House. That discretion is always with him. Now, we are talking of the discretion of a governor post the formation of a government. That's the first issue. So, post the formation of an elected government, if 10 people go to the governor, what is his discretion in the matter? Because the governor has to ascertain, one, that look, these people along with others, the leadership that I will administer the oath to will have the confidence of the House. That's one criteria on the basis of which he'll swear in. Two, he will ask the question, which party do you belong to? He's naturally have to ask. I am sure he will know that before even he asks that question. So he knows, that the Shiv Sena is not before him. On the 30th, he knows Shiv Sena is not before him. So what is his discretion in administering the oath of office to Eknath Shinde? Except the fact that all the 39 rebels will support, or the BJP along with the 39 rebels will oust the government and will support the new chief minister. He also knows, there is a disqualification petition pending. So your lordships will have to decide for the first time in situations of this nature, when there's already an elected government in place and there is a taint, alleged taint of a certain set of members pursuant to the fact that disqualification proceedings are pending, whether the governor can exercise discretion in a manner which will topple an elected government, not await the outcome of the disqualification proceedings. The governor could have done two things. Could have said, I know for a fact that there is a disqualification notice against you all, or against 16 of you. You who want me to administer an oath of office to want to be the chief minister. The court has given you time till the 12th of July. Please first file your reply on the 12th of July. See the outcome of those proceedings. And if there is no taint as far as your membership is concerned, I will administer the oath of office to you. That, I think, is a constitutionally moral path that the governor ought to have adopted. Because institutional morality demands that he follows that path. The Constitution, in fact, persuades him to follow that path. Why? Because there's an elected government in place, of which he was a member. He himself, Eknath Shinde, was a member. So why would a governor administer oath except that he himself knows that the elected government will be toppled? That's a very serious matter, according to me, You looked at the Sarkaria Commission report, your lordships will find no such eventuality, considered. The governor which
eventualities are to be considered on experience.
That's true. That's true. Because ultimately, democracy only thrives when institutions uphold the sanctity of the Constitution. And quite frankly, and this is my personal opinion, no court, no institution should balk from that, should withhold its hands from that. Because ultimately it's the message sent by court, by institutions, that we are above the vicissitudes of fortune that come with politics. That's the only way, to gain respect within the public and to uphold the values for which our forefathers gave us this republic. But unfortunately, that's not to be. So, here there is a big conundrum, very big conundrum. So first, the 27th order, the 29th order, then the governor. Even the governor could have stopped it. But he even chose not to stop it. So your lordships will have to evolve some principle in the context of, because this, if Nabam Malaj is not overruled, this will happen time and again. And the governor will play, I'm sorry to say, Malaj, I've seen the governor, it happened in Arunachal. And we have seen, Malaj, and I mean no disrespect to the institution of the governor, we have seen governors performing a more proactive role as institutional heads within the state, which has created disturbances within the polity.